There is a well-known proverb. I'm sure many have come across this proverb. The saying that it takes a whole village to raise a child. And this proverb exists in many African languages. It conveys a message of devotion, self-sacrifice, sharing, supporting, family relationships, and growth. To echo the African Charter on the rights and welfare of the child, the promotion and protection of the rights and the welfare of the child also implies the performance of duties on the part of everyone. Everyone. So yes, a village to raise a child, a village to protect a child. That village includes mothers and fathers, sisters, brothers, cousins, grandparents, godparents, aunties, uncles. And when I say aunties and uncles, I'm talking everyone who is 5 years your junior. The collective few or many trying to ensure that the best interest of that child is at the foremost in all actions. A village to protect a child. But see, in my vision, that village also includes those who champion the legal protection of a child to preserve their freedom, dignity, and security. The Nigerian Child Rights Act of 2003 expressly states that a child's best interest shall be the primary consideration and be of paramount consideration in all actions. That village of people signifies any and everyone who has the power to refine and strengthen measures that will promote the protection of the Nigerian child or any child living in Nigeria. It is fair to say that there have been many efforts on an international scale towards child rights protection in Nigeria. And these have included adopting the UN Convention on the Rights of the Child with high-level delegation of the government, the Ministry of Women Affairs, pushing follow-up measures and progress, such as enacting the Child Rights Act of 2003 and adopting this law in states of the Federation. The Trafficking in Persons and Prohibition Law Enforcement and Administration Amendment Act 2005, the adoption of policies and strategies to strengthen the implementation of the Convention on the Rights of the Child, including National Plan of Actions involving orphans, vulnerable children, health and human rights. The International Convention on the Protection of the Rights of all Migrant Workers and Members of their Families, to the recent inauguration of the Technical Working Group to coordinate responses to ending violence against children. There's also the National Child Rights Implementation Committee working to coordinate issues of child protection in Nigeria. To mention but a few. But the goal is clear: protecting children from all forms of violence, including from harmful traditional practices, the child labour, the corporal punishments, the child trafficking. It is not contentious. The child protection and other related issues have been repeatedly sounded out as a priority agenda for Nigeria. But it would be simplistic to just say that the time to promote the rights of the child is now. That time was yesterday, and that time is tomorrow, and the day after, until all children feel protected and safe, wherever they are in the world. Where the objectives of the 1996 Hague Convention are concerned, the importance of international cooperation for the protection of children cannot be understated. The reality is that Nigeria is bordered by 4 countries, Benin, Cameroon, Chad and Niger, and shares maritime borders with several others, including Equatorial Guinea and Ghana. Sadly, this reality breeds opportunities for the trafficking of children as a source, transit, and destination country. It is one thing to give legal consent to the UNCRC or African Charter, but it is quite another to have the tools to combat and protect these children in the moment that it matters, on the ground, in the context of cross-border situations. It has already been reflected upon in the 54th session on the Committee of the Rights of the Child where in the reports and observations of Nigeria, the committee commended the frank and self-critical nature of the report, but noted concerns that the link between human trafficking and international protection obligations are inadequate, particularly concerning children trafficked over international borders. There is a lacuna in the system, and it needs to change. It needs to be addressed. The time was yesterday, today, tomorrow, and every day until that change comes. Nigeria in Sub-Saharan Africa comprises of 36 states brought together by a federal system of government and is Africa's most populous country. Recent surveys reveal that children under the age of 15 years, one of the most vulnerable groups, constitute over 40% of the Nigerian population. Coming back to the Child Rights Act, I must emphasize the remarkable efforts in the domestication of national instruments to combat gender-based violence and protect children. In particular, the ongoing UN European Union Spotlight Initiative for championing and protecting the rights and protection of vulnerable groups, including children. Further, Nigeria continues to see progress in the domestication of the Child Rights Act, where though the Child Rights Act law has been passed by the National Assembly, the hesitation by some states has meant that it has not been adopted by all. Nevertheless, recent positive news in respect of Kano State, which has approved the Child Rights Act, and Katsina State, having domesticated the Katsina State Child Protection Bill 2020. The Mother Ministry, a beautiful phrase I heard for the first time in Abuja this summer, is the Federal Ministry of Women Affairs and Social Development. The office is responsible for advancing the social, economic, political, civil, cultural rights and well-being of women and children, including the girl child. Its mandate is advanced through various collaborations and partners. To quote the Permanent Secretary of the Ministry, "Today's children are the leaders of tomorrow. It is therefore imperative that we provide a conducive atmosphere for all our children to excel as they assume the mantle of leadership in the future." The Mother Ministry's leader, Dame Pauline Talon, puts it in this way. Her office, in quote, is deliberately engaging a participatory approach that aggregates the concerns and prioritizes the Nigerian child, while ensuring that their human rights concerns are systematically protected. It was a privilege to have met with Her Excellency Dame Pauline this summer on a mission to Nigeria. After the inaugural event of the Nigeria Group on Private International Law, for which I am very fortunate to chair, Dr. Christophe Berlusconi, the Secretary General of the Hague Conference, suggested that we plan a joint mission to Nigeria. At the forefront of the mission was the renewed efforts to promote the progressive unification of private international law in Nigeria, to speak to key Nigerian officials to discuss HCCH matters. It was clear that for meaningful strides, the stakeholder ministries at federal level were key. And at the heart of the mission, now joint endeavours following months of discussions and planning, with special assistance from the Nigerian ambassador to the Netherlands, we were received by and held key meetings with His Excellency, the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malawi San, and thereafter with Her Excellency, the Minister of Women Affairs, Dame Pauline Talon. It was wonderful to be back in Nigeria. A month before that, of course, I was very fortunate to have travelled to Lagos to speak at a 3-day private conference for the judiciary, ministries and NGOs, organised by the Lagos State Government in collaboration with you. The conference was tailored around a capacity building programme for key functionaries as part of efforts to a strengthening child protection and case management. Where Nigerians' child protection is concerned, at federal level, Dame Pauline expressed sadness Nigeria was not yet a part of the Hague Conference, the global community, especially where families and children are concerned. in no uncertain terms, Her Excellency made clear at that meeting that as the Mother Ministry, it cannot be separated from the issue and children must come first. Reiterating full support, echoing the support that Dr. Berlusconi and I had received from the Attorney General, echoing the support for the need to accede to all 4 children conventions, including the 1996 Hague Convention. Dame Pauline's observations and full commitments to this initiative will no doubt encourage the international family. The ethnic and cultural diversity in Nigeria should be celebrated, but that diversity does not negate a uniformity in pursuit of a better and safer future for the Nigerian child or the child living in Nigeria. To align with the current realities, there are no international child protection frameworks in place, and that needs to change. Nigeria is strongly encouraged to improve the international protection of children by ratifying the 1996 Hague Convention. As we know, the 1996 Child Protection Convention has the primary aim of protecting children in international situations, and it covers a wide range of civil measures of protection concerning children, as well as public measures of protection and care. It can be helpful also in situations involving unaccompanied minors, including refugees, asylum seekers, and internationally displaced children. Not least important is that the 1996 Child Protection Convention complements the 1980 Hague Child Abduction Convention, where inter alia touches on the problem of gender-based violence in circumstances where women flee from abusive relationships and rely on the Article 13(1)(b) grave risk of harm exception to return, arguing the return would expose the child to a grave risk of physical, psychological harm or an otherwise intolerable situation. The 1996 Hague Convention may enable the safe return of the child and parent, with measures that are recognised and enforced by contracting states. In doing so, it enables competent authorities to protect children and cooperate in a variety of cross-border situations. So accession to the 1996 Hague Convention will extend the protection of children in and outside Nigeria beyond the African Road to the 53 or so countries, including Europe, UK, North, South America, Asia, Australia, that are contracting parties to the convention. And so I feel an ongoing responsibility as a practitioner and academic, a British Nigerian, knowing that I am part of that village too, to advocate where advocacy is needed, from words to deeds, so that our leaders of tomorrow journey through life with dignity, security, and freedom. It is always a pleasure to be invited to speak on matters that promote the improvement of the rules of private international law for a cause as important as the protection of children, irrespective of the country or village that they were born in. Thank you.